I'm Ben Meiselas from the MeidasTouch Network. New York Attorney General Letitia James is calling Donald Trump out for his transparent efforts to try to delay the October 2nd trial date that is just around the corner. In New York Attorney General Letitia James' $250 million fraudulent valuation case against Donald Trump, the Trump Organization, and other related defendants, including Eric and Don Jr. In that same case, New York Attorney General Letitia James is seeking at least $250 million in damages. I believe at the time of trial, she will be demanding a number that has a B in front of it. She will definitely be seeking the billions of dollars, in my view. And this lawsuit would also result in effectively shutting down the Trump Organization from doing business in the state of New York. Donald Trump, on an emergency basis, we reported here on the MeidasTouch Network, sought what's called an Article 78 petition that seeks something called mandamus and prohibition relief against the Judge Arthur Engoron, basically saying that Judge Engoron was acting outside the scope of his judicial authority. Judge Engoron's the judge presiding over the case, and Donald Trump is demanding that the First Appellate Department stop Judge Engoron from, I don't know, doing what judges are supposed to do, being a judge. What happened was one judge on the appellate department ruled that on a temporary basis, there would be a briefing period, a very small stay to a 5-judge panel from the First Appellate Division that oversees the trial court to review Donald Trump's Article 78 petition and then to hear the arguments from New York Attorney General Letitia James. It has a return date of September 25th, meaning that the Appellate Division will have to make a ruling by September 25th. And here, New York Attorney General Letitia James says the reason that that date is so critical is we're ready to go to trial, and Donald Trump's writ, this Article 78 petition for mandamus and prohibition relief, it is entirely without merit. It is utterly frivolous. Donald Trump is transparently trying to interfere with judicial processes taking place. And guess what, judges on this panel? Judge Engoron has not yet even ruled on the summary judgment motions. So Donald Trump wants you, the appellate department, to interfere with Judge Engoron making a ruling on the dueling summary judgment motions that have been filed before a ruling even takes place. That is patently unlawful and unprecedented. Let's go through this motion right here. It's called an affirmation in opposition to the motion for a stay of trial filed by New York Attorney General Letitia James's team. And it says how this affirmation is in opposition to the motion by petitioner Trump and these entities to stay the start of trial in an executive law section 6312 civil enforcement action. That's the statute used by New York Attorney General, the Office of Attorney General, against petitioners Donald Trump, while the court adjudicates petitioner's CPLR Article 78 petition. The Article 78 petition, that's this very rare petition that Donald Trump filed to try to block the trial date of October 2nd, to stay it, to put pause on it. It says the Article 78 petition seeks mandamus and prohibition against respondents, the Honorable Arthur F. Engoron, the Justice of the Supreme Court, New York County, who is presiding over the executive law action. Just to be clear, so you're not confused, in New York, the Supreme Court's their trial court. Their top court which is normally a Supreme Court, is called the Court of Appeal. The intermediary court is the appellate department where this is in front of. I submit this affirmation on behalf of the Office of Attorney General solely because Engoron will have to, the judge submits his own briefing based on this challenge. I am familiar with the facts and circumstances of this matter based upon my review of the relevant decisions and orders rendered in the underlying executive law action and the relevant submissions by the parties in the action in this proceeding and through communications with other Office of Attorney General attorneys. So one thing here tactically, reading between the lines of what Donald Trump is trying to do here is, because in a law, like the way this Article 78 petition is framed, it's framed as a lawsuit against the government official who you allege is acting outside the scope of their government official authority. Article 78 petitions against a judge in New York are exceedingly rare. You often see these brought in like administrative hearings. So what Donald Trump is trying to, if they're brought at all, and still rare there, what Trump is trying to do, obviously, is to bait Engoron into saying something like it's frivolous, it's without merit. And then what's Trump going to do? What we see time and time again with MAGA lawyering, whine and complain and say, oh, look, the judge is biased against me and now needs to be disqualified. So watch out for that. I think Engoron knows where Trump is going with that. A single justice of this court issued an interim stay of the trial start date in the underlying executive law action without any determination of the merits, and referred petitioners' request for a stay of trial pending adjudication of their Article 78 petition to a panel of this court on an expedited basis. Office of Attorney General requested and the single justice granted a return date of September 25th, 2023 on petitioner's stay request so that the court can review the motion and decide it before October 2nd, 2023. So all of this needs to be decided, New York Attorney General Letitia James says, before the trial date, because we're ready to go to trial. This motion's without merit. Let's go. It goes on to say the following. The stay motion should be denied because petitioner's Article 78 petition is a brazen and meritless attempt to have this court issue a writ that usurps both Supreme Court's broad discretionary authority to manage its own docket and the Supreme Court's fundamental judicial role to render substantive legal rulings on the parties' cross motions for summary judgment in the first instance. Mandamus and prohibitions are not available for such ends. To rule otherwise would upend the judicial process. It would. What Trump is saying is, first appellate department, jump in before Judge Engoron, the judge presiding at the trial level, even makes his ruling. It's not the way our system works. But by the way, you saw Donald Trump try to do this and fail, for example, in Georgia, where Donald Trump went right to I know it's a little confusing because in Georgia, the Supreme Court is the top court. In New York, the Supreme Court's the trial court. But in Georgia, Trump went directly to the Georgia Supreme Court, filed a motion with them, telling them to stop what all the lower courts are doing. That's not the way the system works. That's not the way our judiciary system works. And then it goes on to say, petitioners thus have no likelihood of success on the merits of their petition, and the court should deny the stay motion on that ground. Mandamus and prohibition cannot be used to predetermine the trial court's forthcoming substantive legal ruling on the parties' currently pending cross motions for summary judgment. Indeed, mandamus and prohibitions are not available to challenge summary judgment rulings that have already issued, let alone summary judgment rulings that have yet to issue. Yet that is the meritless premise of the entire petition here. So here what New York Attorney General Letitia James is saying is, you couldn't even get this type of Article 78 mandamus and prohibition relief if Judge Engoron made a ruling on the summary judgment that you don't like. That's not the way it works. What happens is you go through trial, and then there's a final judgment, and then you go through an appeal process. But here, Donald Trump is doing, even before the Court of Appeal would normally even get to hear it at all, before summary judgment is even ruled upon by the Supreme Court judge, Donald Trump, the trial court judge, Donald Trump saying, I want this quasi-writ appeal that he wouldn't even have after summary judgment. One other very important point on this motion that was just brought, or opposition that was just brought, it also lays out the trial schedule of all of the cases that Donald Trump has. And it basically says, look, New York Attorney General's office is ready to go. They would be severely prejudiced by even a brief delay of the trial pending adjudication of the petition. The Office of Attorney General has been extensively preparing for trial for months, including preparing dozens of witnesses. Such witnesses have planned on trial starting October 2nd, and rearranging their schedules will impose unnecessary and substantial burdens on them. Moreover, even a short stay of the October 2nd trial date is likely to create a cascade of delays in not only this case, but other litigation involving Donald Trump. Mr. Trump is a defendant in several other matters currently heading to trial, including a January 15, 2024 civil trial in E. Jean Carroll, March 4, 2024 criminal trial in Manhattan District Attorney, the People versus Trump case, Manhattan District Attorney case, May 20th, 2024. The March 4th, 2024 Special Counsel Jack Smith federal case, March 25th, 2024 Manhattan District Attorney case, May 20th, 2024 Florida federal case, and then it has, if the start of this trial date is delayed at all, it would upend all of these dates. So a powerful motion, and then laying out all of those trial dates right there, folks. Strong motion by New York Attorney General Letitia James. We'll keep you posted on what happens. Hit subscribe. We're on our way to 2 million subscribers here on the MeidasTouch Network. It's free to subscribe on YouTube. If you want to help out this network grow a little more, go to patreon.com/MeidasTouch as well. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.